Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
Hi, everyone. Welcome to Off the Clock. This is Rebecca Strauss with Miller Johnson. With me today is my friend and colleague, Michael Nye. Michael is an intellectual property lawyer, a patent lawyer, but please don't turn off your screen or turn off the podcast just yet. I promise this episode will be filled with information. We're going to talk about how to keep your organization's information secret, right? The information that gives you your competitive edge, including information on the latest regarding non-competes and the federal rule that may eliminate them across the country. Welcome to Off the Clock, Michael.
Hey, thank you, Rebecca. It's nice to be here.
You are my second favorite patent lawyer. My first favorite, some people know, my husband is a patent lawyer, so I do have a soft spot.
I would have settled for top 10.
Darn it, I should have said that. Well, welcome to Off the Clock. It's your first time visiting us. I should note for viewers that are used to seeing me talking with Sarah or others in the same room, obviously we are not in the same room. We are recording in the winter in Michigan. You are in our new Detroit office, right? And I'm on the west side of the state. So
yeah, in fact, our kids' school was canceled because of the snow.
Okay, so let's get going and let's start off talking about non-competes, because I think that of all the concepts we're going to discuss today, probably non-competes and non-disclosure agreements is what is most familiar to most of our listeners. And many people may have heard the news that recently the Federal Trade Commission, the FTC, has proposed a rule that would essentially make non-competes unlawful across the country. Right now, it's a very state-by-state type of issue. We already have states that make them unlawful, most notably California. But this would be a national rule. There are a few exceptions, but not many. There's notifications required. There's a lot of details. And if this actually does become the law of the land, we will get into much more detail on what is required. For now, what everyone should know is that the rule has been proposed. It's open to a 60-day notice and comment period, at which point it could be tweaked, right, from the proposed rule that we've all already seen. And then the FTC will decide whether to publish a final rule and what details will be included in that final rule. Like almost every agency rule in the last few years, we expect it to be challenged in court, right, as an unlawful exercise of the FTC's authority. In other words, just like the OSHA vaccine rule and others that people are more familiar with, the agency doesn't have the power to do this. You and I have no idea how a lawsuit like that would play out, right?
That is correct.
So what we are going to do is we are going to talk about ways to protect organizations' secrets with or without non-competes.
This is just a good reminder that if non-competes get limited, that these are even more important things.
In addition to non-competes, a lot of organizations have a thing called non-disclosure agreements, which we refer to as NDAs. They're sometimes referred to as confidentiality agreements. We're not going to go into great detail on those, but that's another tool in the toolbox that a lot of organizations use to keep secret, right? But let's talk about what is available other than non-competes and non-disclosure agreements that people may be less familiar with, and we really want people to think seriously about. And I would love to start by asking about trade secrets.
Sure.
What is a trade secret?
Yeah, so anything that is secret and derives economic value from being secret could potentially be a trade secret. So that might be a customer list, it might be a pricing strategy, or might be your marketing plan.
Let's pause there for a moment because I want to make sure people let that sink in. I think when a lot of people hear trade secret, they think secret formulas, right? Recipes. So you're telling us that customer lists and pricing information could be trade secrets?
Absolutely. So it meets the definition in the statute. It's something that you are keeping secret, and it's something that has economic value because of its secrecy. And it's something that your competitor might find economic value in if they were able to get access to it.
And what's cool about information being covered by being encompassed by the phrase trade secret is it's protected even if your employees didn't sign an NDA or a confidentiality agreement, right?
Yeah, that's absolutely right. So it's a statute. There's a federal and a state by state statute. So trade secret protection exists regardless of what agreements you might or might not have with your employees.
So this provides protection over secrets, regardless of any contracts. That's fantastic. So let's talk about then, what do people need to do to make sure that their secrets are considered trade secrets if they have to go enforce a trade secret down the line?
Right. So all of the statutes have a similar requirement that you have to make reasonable efforts to protect the secrecy of your trade secret. So it's not enough to have something that you don't want people to find out. You actually have to make reasonable efforts to prevent it from getting out.
What the heck is a reasonable effort? Just asking on behalf of our listeners.
Right. So the lawyer answer is it depends. But the much more helpful answer is that it's policies. So you have to have a policy that people need to keep trade secrets secret. You need to train them on that policy. So that policy might be, don't have it on a thumb drive that you are throwing into your backpack. It's something that you might want to say can only be accessed inside the building, or it can only be accessed through a secure network. You also need to have practical controls. Now, the extent of how controls or how much controls you have that's where it depends comes in. But you probably want to have digital controls so that not everyone in the organization can access it. There might be a special place where you keep the things that are more highly sensitive than just your everyday business information. You also ideally would log it, so people understand that when they access this, a log will be created, and that reminds them of the importance of keeping it secret. It also helps you to track it. If an employee leaves and you have a log showing what they downloaded the hour before they left, that's all very helpful in establishing that something is a trade secret and whether it was taken.
That's fascinating. And I bet that's a process that a lot of listeners aren't following right now. So let's go through it step by step. So step one is to develop a trade secret policy, which could be included in a confidentiality policy, right? Because a lot of clients have those already.
And then that policy that you so lovingly prepare needs to get communicated to the employees and not just put into a filing cabinet.
We say that all the time, right? A policy is not really a policy, right? If no one's trained on it and follows it.
Right.
And then you and I, before we started recording, talked about the advantage of clients making a list, like literally listing out the information that they consider to be their trade secrets, right?
Sure. Yeah. I mean, it's not a bad idea as a business to consider what gives you your competitive advantage and what secrets you want to keep secret to maintain that competitive advantage. And certainly when it comes to keeping your trade secrets secret, you have to know what they are. Because if you don't know what they are, there's no way that your IT folks can make sure that they're protected. And you might want to label them so that when someone has a pricing memo, it says at the top, confidential, trade secret. So you realize, oh, this is not something that we just hand out to every customer. It's not something I can leave on the train on my way home.
Got it. So first you need to get together and think about what your trade secrets are. Work with IT, right? So that we can, because most things are digitized, most information is digital now.
Sure.
So when we talk about restricting access in the olden days, right, there'd be a key on a file cabinet, but now it's really an IT issue, restricting who has access to what information. IT is not going to know that without a list, right? And think about where those things are stored electronically. And then I just think that's brilliant to keep a log of who has accessed those specific files, right?
Absolutely. Yep.
Okay.
Yeah, that's one of the most important parts of security is, controlling the access and also monitoring the access.
Perfect. So if we do all of those things, and then let's just say an employee does not have a non-compete and goes to work for a competitor, right? And we see that we believe that information is being used by our competitor. Now we might be able to take legal action for theft of a trade secret, right?
Absolutely. And there's both civil and criminal penalties for misappropriation of trade secrets.
What about for the person that uses it, but that didn't take it? So the salesperson leaves, intentionally takes it knowing it's a trade secret, et cetera, takes it to a competitor and the competitor starts using it, can the competitor be liable?
Absolutely.
This is a good time to pause for a PSA, for a public service announcement, that means when you are hiring people, right, you have to be careful that you are not using the trade secrets of your competitors.
Absolutely.
So trade secrets, I think I've got my head around it, and that can be a very effective tool. Again, particularly if there's not a non-compete, but even if there is. So I often think of trade secrets as like the exact opposite of patents. And yes, folks, we are going to talk about patents. We're going to keep it short and tight, I promise, right? But there is information you all, I think, will really want to know about patents that can, again, be another tool in your toolbox, right? Maybe you'll find it useful, maybe you won't. As a non-patent lawyer, I promise you'll understand it. Michael and I talked ahead of time.
It's the 99% of patent lawyers that make the rest of us seem boring.
I cannot retell that joke at home, but it's very funny.
Yeah, exactly.
Okay, so we're all—
Don't tell anybody I said it.
All of us non-patent lawyers, and I'm one of them, and including non-lawyers that are listening, we're all going to take a deep breath, hold hands virtually, and talk about patents. And I want you just to explain, like, Larry, just in layman's terms, what is a patent, and why do people like me that know just this much think about it as the opposite of a trade secret?
So a patent is, it started back in the 1700s. It's something that's existed for a long time, but it is simply a quid pro quo. You're trading one thing for another. You are going to tell the entire world what your invention is, how it works, how to make it. And in return, the federal government will give you 20 years of exclusivity. So that means that if the patent office gives you a patent, no one else can use or make or sell your invention for 20 years.
Okay, Michael, I know you do a lot of client counseling. You don't just help people get patents, which you do, but you also talk about strategy with organizations, right? Do they want to get a patent in the first place? As someone that doesn't do that work, and as a person that thinks more about confidentiality and secrets as an employment lawyer, why in the world would an organization want to tell the whole universe one of their secrets, one of their things that gives them a competitive edge?
Yeah, absolutely. So a trade secret, in order to enforce that against a competitor, you have to show that it was misappropriated, it was taken from you. Whereas with a patent, the patent is an exclusive grant from the government to your invention. So even if somebody else independently invented it, even if this competitor has never heard of you, never seen your invention, the patent can still allow you to keep them out of the market or to give you a royalty. So it's a broader scope of protection. One of the downsides, of course, as I said, it's 20 years. So if Coke had gotten a patent on their formula, it would have ended 50 years ago. So they're glad that they kept it secret forever, or for as long as they possibly can, because a patent, you give away all the information and in return get 20 years.
So that is a very strategic decision then.
Any good IP lawyer will be able to go through, there's a whole list of things you can consider when trying to protect something as a patent versus a trade secret. But just one strategy to keep in mind is that you can actually file a patent application seeking a patent and ask the government to keep it secret, so that only if they decide to give you a patent and you get your 20 years of exclusivity, only then does it become public and you lose it as a trade secret.
Again, as a non-IP lawyer, when I think of patents, I think of inventions, I think of gadgets, I think of, you have actually framed patents behind you, because that's the kind of guy you are, and it's Tesla's invention. That's the sort of thing I think about with patents. So if I'm listening and my organization, right, didn't invent a thing that we produce, that we manufacture, what are patents still relevant to my organization? What other types of things can be patented that I might not have thought of?
Whenever you come up with a technical solution to a problem, there's the possibility of getting a patent for it. So it doesn't have to be a device. It doesn't have to be a way of wirelessly transmitting power between two towers. It could be something like the Amazon one-click patent. So Amazon came up with the idea that instead of having to add something to a cart and then do a checkout process, you could do one click and use stored information to complete the transaction. So that sounds like, oh yeah, that's just a business process. Those have gotten more difficult to protect in the last 10 years. So you certainly need someone who knows how to navigate that area, but those are the sorts of things that you can still get a patent on, as long as there's some technical underpinnings there.
Okay, so that is surprising to me, and but perhaps surprising to people listening too, right? The little light bulbs, no pun intended with your Tesla thing behind you, but might be going off over the top of their heads right now, right? Thinking about things their IT department's problems their IT department has solved for them, right? That might be patentable. And as an employment lawyer, what comes to mind is application processes, right? I know some organizations have figured out technical solutions to move the application process through as quickly as humanly possible, or as technologically possible, right? To beat their competition. When someone applies online, they want to be the first ones to respond. Is that something that could potentially be patentable?
Absolutely. And mostly because you used the magic word technical. If all you're doing is taking an existing HR process and say, and now we do it with a computer, that's going to be almost impossible to get through the patent office. But if there's something technical about it, perhaps the way you're doing an automated communication back to the applicant, or if perhaps there's a technical way that you're extracting information from their PDF resume and putting it as something that, you know, the HR or hiring manager could actually use to compare applicants, those sorts of things are potentially patentable.
If non-competes are no longer a tool, that's what's on my mind. And lots of non-competes are used for salespeople, right? That's one of the principal types of employees that employers use non-competes with. That's what they're most concerned about, right? And when it comes to salespeople, in addition to just human relationships, they're concerned about customer lists and pricing, right? Information that salespeople have. So, but also perhaps about processes, right? Sales processes. How do we, from the time a salesperson is in the field, right, to the time that we can process that order and start fulfilling it, if IT has invented a process, right, a technical process to speed that up and speed up the timing of it, the accuracy of it, right, making the pricing more specific, right, all of that, could that be patentable?
Yeah, and again, as long as it's not simply encoding, well, Alice gets the sales lead, she carries it to Bob, who then calls the customer back. Well, now the computer carries it from Alice to Bob. That's not going to be patentable. But to the extent that you have some sort of technical solution that makes it more efficient, that perhaps does some sort of automated checking that, you know, a human might not be able to do, even if they had more time, that's where you have a lot more likelihood of getting a patent.
So, Michael, that was all fascinating, especially for, again, a non-patent lawyer. Thank you for explaining things in a way that I and hopefully all of our listeners can understand. Now let's turn to the practical side of this, like the super practical. Like, after listening to the show, what should listeners do now? And we can kind of go back and forth on this. My first suggestion is to think about whether they want non-competes or not. If they have non-competes, why they have them in the first place, and whether their goals can be accomplished through other tools, right? So that way, if this rule goes through, it won't disrupt their business. In my experience, non-competes are attractive, not so much to prevent a valuable employee from working for a competitor, although certainly that's part of it for some organizations. But it seems to me it's most often used as a fence, right? Non-competes are used as a fence around what's really important, which is secret information, private information of the company, pricing, customer lists, inventions, right? Processes, things like that, that really give an organization a competitive edge. Once a valuable employee leaves to go for a competitor, we don't know what they're saying every day, right, in their new place of work, hence the non-compete. If they can't go and work there in the first place, then we don't have to worry about the employee sharing our private information, right? So if that is the reason that a non-compete is valuable to you, think about alternatives, which is non-disclosure agreements, right? You are prohibited from sharing our private information. What's fun about non-disclosure agreements or confidentiality agreements as opposed to trade secrets is you can define private information however you like, right? With trade secrets, as you mentioned, Michael, it's a law, right? It's a statute.
Right.
And the statute tells us what is a trade secret or what is not, as long as you go through the reasonable precautions that you mentioned. But in a confidentiality agreement, right, you have more flexibility as to how you define things and how you define damages. Think about non-solicitation agreements as an alternative. So a non-solicitation agreement doesn't prevent an employee from working from a competitor, but it does perhaps say you can't solicit our clients. It does perhaps say you can't solicit our current employees to leave, right? It does perhaps say you can't contact our vendors, right? It does say you can't encourage anyone to stop doing business with us. So those are non-solicitation agreements that are just shy of being a non-compete. And you might want to think about that either as an alternative to a non-compete or included in your non-compete agreements, right? What other types of tools should our clients be thinking about, Michael?
Yeah, so a good idea, regardless of what happens with non-competes, is to tighten up whatever trade secret policies you have and make sure they're inventoried, make sure you know what they are and that they're being protected. To the extent that you have anything that you think might be patentable, you can reach out to your IP lawyer or reach out to your employment lawyer who might know an IP lawyer and explore that idea. The one caution I would have is you can't keep something around using it in commerce, kind of keeping it secret and then try to apply for a patent eventually. There are specific time limitations, plus or minus a year. So if you've been using something for more than a year, you might not be able to get a patent on it. So that's the one caution I would say take away from this is if you're thinking about a patent, ideally you would talk to your IP lawyer before you started using the invention, but certainly within 1 year of starting.
Got it. So what I'm thinking about, again, my non-technical mind, is almost like a spreadsheet, right? Listing all of the things that give you your competitive edge that are not generally known, right, in public. So these would be your secrets, which would be my layman's way of saying it. And then maybe in an Excel spreadsheet, right? And then in another column, what is going to be our strategy for keeping these secrets secret? Right? And is it going to be a non-compete? Is it going to be a non-disclosure agreement? Is it going to be going through the steps you just mentioned, right? To keep it a trade secret? Do we want to consider patenting, right? Which again is not actually keeping it a secret, but at least prevents our competitors, right, from using this against us. And there's pros and cons to various different tools, and it's definitely something leadership should talk over with an attorney. Let's switch from intellectual property and patents to employment. Michael, from an intellectual property perspective, what would you like to see in those employment agreements?
So certainly you want to make sure that the company is getting the IP that the employee is creating. You certainly want to talk to your employment lawyer because there's some restrictions. California, just like with non-competes, they have some restrictions on what inventions must be assigned to your employer. But I've seen a number of times where the language around assigning patents and inventions to your employer is a little bit weak, and it's actually led to some very, very serious losses to companies that didn't have the right language in place.
Let me just flesh that out for a moment. So because this is unbelievable to people that haven't had to deal with this before. So what you are saying is that if my company hires an engineer, I ask that engineer to, let's just say, invent something, create something for my company. I am paying that engineer to do it. That engineer then does it as part of his job duties and what I'm paying him for, or he or she, that my company does not necessarily own that invention?
That's correct. Yeah, there's other economies like Germany where they have a law that says, no, if you're doing it in the scope of your employment, it goes to the company. But in the US, we handle that through employment agreements. So your employment agreement must say that it gets assigned to the company. Otherwise, you just have to ask your engineer to sign an assignment agreement. And you would much rather have the language in place that makes that automatic rather than having to go to ask them.
But we see these kinds of clauses a lot in healthcare agreements, right? Because a lot of physicians and other people just throughout the course of their work, right, come up with ideas. Even people who are not in R&D or not engineers, right, can come up with a great idea or an invention.
Yeah, plenty of great tools and surgical procedures have been invented by doctors, and sometimes they start companies based on that.
something I'd like to see in an employment agreement. I hinted at this earlier, right? So not only are trade secrets you can use as a weapon, right? To help protect your secrets, trade secrets, confidentiality agreements, et cetera. But what happens when you hire someone, right, who has important information from your competitor? Well, they're going to be thinking about all these, everything Michael and I have talked about today. It's not a secret, right? So they're going to be thinking about the same things that we've talked about. They're going to be thinking about, did they steal our trade secrets? Did they violate their confidentiality agreement when they went over, et cetera, et cetera. So something employers can think about if they want to protect against that. And this is really a case-by-case factual basis type of decision to make, so we can talk it through together. But something you should think about putting in your employment agreements is an affirmation by the new employee that they did not take any of their former employer's trade secrets with them, that you will ask them if they have a non-solicit or a non-disclosure agreement with their previous employer, and that they affirm whether they do or don't, and they affirm that they will not violate that agreement while working with you. You can even go further and say no compensation will be based right, on you bringing that information over. We do not expect you to use it as part of our job duties. Depending on the type of job and the way you compensate people, you can even consider restricting compensation, right, to only clients that come over or projects that they work on, et cetera, that are not related in any way to their previous employer, or that could raise suspicion, right, that they're using trade secrets or confidential information in their new job. So that is not in every employment agreement, but it is something you should think about depending on your specific industry, right? Your competition, the litigiousness, perhaps, within your industry, et cetera. So Michael, this was so fun. Who knew talking to a patent lawyer could be this fun?
But you did, but most people don't.
Thank you for explaining things in a way that hopefully everyone can understand. Good luck surviving the storm in Detroit, and we'll see you soon.
All right, thank you very much.